Hello and welcome to our ethical lawyering class. In this class, we are going to be continuing our discussion on the duty of confidentiality. In our previous classes, we looked at this duty of confidentiality broadly, as well as a specific duty of solicitor-client privilege. In the last class, we started conversation on the exceptions to the duty of confidentiality, and we discussed specifically the crime, fraud, communication exclusion to this duty, as well as the future harm or public safety exclusion or exception to the duty. We also looked at some of the general exceptions provided for in rules and sub-rules 3.3 and 3.4 of the Law Society of Alberta Code of Conduct. So in this class, we are basically going to be continuing our conversation on the exceptions to the duty of confidentiality. So we're going to be looking at additional exceptions to the duty of confidentiality, that is in addition to the ones we have considered in the previous class. So for this particular class, we are going to start by looking at the exception known as the innocence at stake exception. This is a case law exception to the duty of confidentiality imposed on lawyers by the Code of Professional Conduct or the rules of the profession. And this exception arises where there is the risk of an innocent person being wrongly convicted for a crime, that is cases of wrongful conviction or risk of wrongful conviction. Now, to understand this rule, it's important to lay out this explanation to two competing rights that are at stake with regards to the innocence at stake exception. Right. So on one hand, we talk about the solicitor-client privilege, right? An accused person has the right to full answer and defense where they are charged of a crime. This is a charter-protected right. Okay. So in essence, that means an accused person should be granted access to information they need in order to prove their innocence where they are wrongfully charged of a crime. So that is a charter right. Now, the solicitor-client privilege also arises, on the other hand, where that information that is needed to prove the innocence of this accused person are actually solicitor-client privilege information of a third party who is not really involved in the criminal prosecution of this particular individual in question here. So to illustrate this, so let's use the example of X and Y, two different individuals. Let us say Mr. X is standing trial for a crime that they have vehemently asserted that they did not commit. They're basically asserting their innocence, right? Mr. X is entitled to information that can enable them to prove their innocence. Now, let us say Mr. Y is, let us say, a convicted felon in a federal penitentiary or jail, or a convicted felon in a jail. And there are evidence to show, or there's the likelihood that this individual, Mr. X, has actually confessed to his lawyer that in addition to the crime for which he is being incarcerated, he was actually the one that committed the crime for which Mr. X is being charged. Now, such information, where they are available at trial, it will go a long way in proving the innocence of Mr. X. But the fact that Mr. Y has made this confession to his lawyer, maybe in the course of their lawyer-client relationship, that information is solicitor-client privilege and confidential, and it cannot be disclosed. While the disclosure of that information is vital for Mr. X in order to prove his innocence. So an accused person has the right to full answer and defense, which is a charter-protected right. On the other hand, the convicted fellow who had confessed to a crime for which X is charged also have solicitor-client privilege, right, which is also a charter-protected right. So the question then is, when you have these two charter-protected rights of these two individuals, when these two rights conflict, which one should prevail? Should the innocent person, Mr. X, be granted rights over those solicitor-client privilege, in essence, abrogating or breaching the solicitor-client privilege of Mr. Y in order to prove the innocence of Mr. X? So this is kind of the situation or that gives rise to the exception we are about to consider. So one of the questions that we need to answer now is, how do you resolve these two conflicting and actually equal charter rights? Which one should precede over the other? Now, to resolve this issue, we are going to look at a particular case law where such an issue arose and the principles that were developed in that case law that should guide us in seeking to resolve these two conflicting rights. And the case we are going to be looking at here is the case of R and McClure. Okay. So in R and McClure, there an accused person was charged with a number of sexual offenses in a criminal proceeding. Now, one of the complainants whose complaint led to the charge of sexual offense against the accused person, so one of the complainants also filed a civil lawsuit against the accused person. And that civil lawsuit, of course, is completely different from the criminal trial or the criminal charge. Now, the accused person in the criminal trial, to make full defense in the criminal trial, they sought access to privileged documents in the complainant file in the civil litigation file. So an accused person, of course, in criminal case, just like the accused here, has the right to full answer and defense. And according to the accuser, to make that full answer and defense, they need to access the civil file or the civil litigation file of the complainant or one of the complainants here. So the question then is, how do you balance this right? The accused's right to full defense, full answer and defense, and the complainant's right to solicitor-client privilege documents in their civil litigation matter or their civil litigation file. Well, this case went as far as Supreme Court, and in Supreme Court, the Supreme Court acknowledged the fact that in limited circumstances, emphasis on limited circumstances, that solicitor-client privilege could yield to accused's right to establish their innocence. That is, the accused's right to full answer and defense. In limited circumstances, solicitor-client privilege could yield to this right. However, in this particular case, the Supreme Court denied access to the civil litigation file of the complainant. According to the Supreme Court, of course, the reason was because the test for disclosure was not met in order for the right of the complainant to their solicitor-client privilege information to be kind of abridged in order to allow the defendant in the civil criminal matter to make full answer and defense. So one thing we note here is that the Supreme Court noted that there's a test for disclosure, and that test has to be met before an accused's right to full answer would trump the right of a third party to their solicitor-client privileged information. So that takes us now to the test for disclosure in the innocence at stake, for the innocence at stake exception to arise. So let us look at that text. But one thing we have to note here is this. There are various steps that have to be taken in order to decide whether the accused's rights or the innocent at stake exception will apply. Before that, the test for disclosure is even undertaken, there is a preliminary step that has to be undertaken first. And the first step there is that the person, that is the accused, who is seeking to access the solicitor-client privilege information of a third party, first of all, we need to prove that that information for which they are seeking from that third party, that is the solicitor-client information or privilege information, which they are seeking from a third party, is not available from any other source. And that the accused cannot raise a reasonable doubt of their guilt in any other way. So let us illustrate this situation this way. Let us say an accused person, in this case, Mr. X, who is, say, accused of a homicide, which they didn't commit. Let's say at the time that homicide was committed, they were not even present at the scene of the crime, which of course gives rise to very good defense of alibi. So let's say at the time this crime was committed in Calgary, Mr. X was in Vegas, right? And he was, let us say, in casino in Vegas, where there is video recording that will show his presence there, which will establish a clear defense of alibi. If such evidence exists, then this preliminary step has not been met because there are other sources of information, or the information relating to his innocence will be obtained from other sources. The accused in this case will be required to go through those sources to obtain those information, even though it might be more time-consuming and more costly to obtain. That will be the source of the information. They will have to obtain the information using that source as opposed to, compelling the disclosure of the solicitor-client privilege information. So the preliminary step that has to be established before we even go to the innocence at stake test is, one, the accused person has to show that the information source is not available from any other source, or the solicitor-client information is not available from any other source. And that without that information, the accused cannot raise a reasonable doubt about their guilt. Once this preliminary step is met, then that is where the court will now have to conduct the innocence at stake test. And the first stage of the test will require so let us now talk about the first stage of that test. So stage one of the test, the question the court will be asking at stage one of the test is this: is there some evidential basis to suggest the existence of the solicitor-client communication, which could raise a reasonable doubt of the accused's guilt? The essence of this stage is to ensure that the accused is not on a fishing expedition. So this is not a case where maybe the accused says, well, it's likely that Mr. X or Mr. Y confessed to this crime to their lawyer. If we are able to search the lawyer's record, we'll probably come across information relating to that confession. This is just this case is just in this situation, this would be a mere fishing expedition because there is no basis, evidential basis to even suggest that such information exists. So this would be different where, for example, Mr. X in this case says, well, Mr. Y did confess to his lawyer, and when this confession was being made, that Mr. Y's ex-partner was present there. Maybe the reason why she hasn't spoken before was because the relationship was going, but now that relationship has gone bad, she has actually brought this matter or made this matter, communicated this particular issue to some people, that if she is, and that she probably is willing to even depose under oath to assert that that communication took place. In this case, there seems to be evidential basis to suggest the existence of such confession by Mr. X to their counsel. So once the evidential basis is established to exist, the court will have to look at it to see whether that evidential basis could raise a reasonable doubt as to the guilt of the accused. So the essence of this first stage is to prevent fishing expedition. There must be some evidence to suggest that the solicitor-client communication or information exists, and that information could raise a reasonable doubt about the guilt of the accused. So the example we have used in this case, if Mr. Y, there's evidentiary basis to suggest that Mr. Y did confess to his lawyer that he was the one that committed the crime for which Mr. X is being charged, that could raise some reasonable doubts about the guilt of Mr. Y. So having raised or having proved or shown the existence of such solicitor-client communication or information that could give rise to reasonable doubt, that will now take the court to the second stage of the test. And this second stage, the court will now have to determine whether the communication, which has been examined by the judge, is likely to raise reasonable doubt as to the accused's guilt. So the first step is whether the information or communication could raise reasonable doubt. And the second stage is, of course, the second stage at this point now, the judge has reviewed the communication of the information. So at this point in time, the question will now be whether that information, which has been seen by the judge, is likely to raise reasonable doubt. So at this stage, a certainty that it will raise reasonable doubt is not required. It's the likelihood of it raising reasonable doubt. So what is the difference then between stage 1 and stage 2? Well, among many others, the difference between the two stages is that at the first stage, we are not even certain whether the communication did exist, right? So there's still more like, we need to resolve some doubt as to the existence of the communication. And that if the communication existed, then it will raise reasonable doubt. So there is doubt surrounding the existence of the communication in the first stage. At the second stage, we don't have any doubt anymore about the existence of the communication or alleged communication or information. What we are concerned at this point, because of course, the information or communication at the second stage has been proven to exist, and the judge has reviewed the communication. So at the second stage, what we are concerned now is whether it is likely, or the likelihood of that communication raising reasonable doubt. So once these two, this first and second stage has been cleared, or these two tests has been met, then such disclosure will be permitted under the innocence at stake test. So another important point that may need to be highlighted from the Supreme Court decision in R. and Brown has to do with the extent of the disclosure that will have to be made in this case. So when it has been shown that the information or communication is likely to raise reasonable doubt about the guilt of the accused, the information has to be disclosed, but that disclosure must be limited to the part of the evidence or that communication which is relevant to prevent wrongful conviction or to prove the innocence of the accused, or in essence, prevent wrongful conviction. So that's the part of the evidence that will be disclosed under the test. Another important point, of course, to prevent the harm that will be done to the owner of the solicitor-client privilege information, which is Mr. Y, where such disclosure is made, the holder of the solicitor-client privilege is granted a sort of immunity against subsequent use of their privileged communication. So that information can only be used for the purpose of asserting the innocence of the accused. The prosecution cannot, on the basis of that disclosure, use that information now, or solicitor-client privilege information, to commence prosecution of Mr. X for that crime. In fact, Mr. X has immunity against subsequent use of such disclosed information. So that is at least a step, taken by law to prevent the harm that will be caused to the holder of that solicitor-client privilege information as a result of, that solicitor-client privilege information being used, or basically their charter right being infringed for the purpose of asserting or preventing, for the purpose of preventing the wrongful conviction of the innocent person. So that is the innocence at stake test, which was developed in R and McClure. Now we are also going to proceed to look at another exception to the duty of confidentiality. And here we are going to be looking at a special exception which arises where a lawyer seeks to withdraw from representation of a client. The Code of Professional Conduct provides various reasons or scenarios where a lawyer, in one case, must withdraw from representation, and other cases where they may withdraw from representation. Now, when a lawyer seeks to withdraw from representation, in most cases, they will have to inform the court or the judge as to their withdrawal from representation. Now, what happens if the judge, when a lawyer is seeking to withdraw from representation, seeks to know the reason why the lawyer is withdrawing from representation? Now, the reason that the lawyer is withdrawing from representation or giving that reason in open court may actually entail the disclosure of confidential information about the client. So it's the counsel, because they are withdrawing from representation, discharge of their duty of confidentiality, as of which they can now go on and disclose those confidential information to the judge to justify their withdrawal from representation? The answer is no. The answer is no, because the duty of confidentiality continues even when a lawyer seeks to withdraw from representation, irrespective of how the lawyer-client relationship ended, whether it ended amicably or in most cases, in this case, whether it ended acrimoniously. You are still duty-bound to uphold that duty of confidentiality. So, seeking to withdraw from representation may put a lawyer in an ethical dilemma, where the lawyer will now have to seek to balance their duty of confidentiality to the client on one hand, and on the other hand, seeking to justify before the court or before the judge the reason for their withdrawal from representation. As a lawyer, you have an obligation to resolve this dilemma, resolving it in such a way that your client's rights to confidentiality is not jeopardized. So the question then is, how do you resolve this dilemma for a lawyer who finds themselves in this situation, trying to uphold the duty of confidentiality by not disclosing the client's confidential information, and on the other hand, trying to convince the judge that they should let you go and should not allow you to continue to represent or compel you to continue to represent the client in that matter? So how do you resolve this conflicting situation without jeopardizing the client duty of confidentiality? Well, we are going to review a case law which came, of course, before the Supreme Court, where the Supreme Court set the principles that will be vital or will help lawyers in being able to resolve such ethical dilemma when they find themselves in such situation. So the case we are going to be looking at here is the case of R and Cunningham. So in R and Cunningham, counsel in that case sought to withdraw from representation of an accused person in a criminal matter because of non-payment of fee by the accused person. And let's be clear here that one of the grounds for withdrawal from representation, which is permitted under the Code of Conduct, is non-payment of fees. The Code of Conduct clearly provides that a lawyer may withdraw from representation, that is discretionary withdrawal, for non-payment of fees. So that's exactly what was sought to be done in this particular case. The counsel sought to withdraw because the client wasn't willing or wasn't providing payment for the fee, and the judge refused the counsel's request for withdrawal from representation. And that case went as far as the Supreme Court. So the Supreme Court laid the following principle to with regards to withdrawal from representation. The court was of the view that if counsel seeks to withdraw from representation and timing is not an issue, then the court shouldn't even go into the business of inquiring the reason for their withdrawal. So if a matter hasn't been set down for hearing, there's still time for the client to retain for this, if this lawyer goes, there's still time for the client to retain another lawyer and sufficient time for that lawyer to prepare for the matter before trial, then there's sufficient time, or timing is not an issue in this case. So the court should not even ask the lawyer the reason for their withdrawal, right? Of course, the idea is there's no need going into that or putting the lawyer in such a position that they will be tempted or fall into the risk of trying to provide the judge or the court with confidential information about the client in order to justify their withdrawal. So if time is not an issue, don't ask, don't inquire. Just let the lawyer withdraw. That was the instruction to the court. Now, if timing was an issue, the Supreme Court was of the view that the court may inquire further, right? In this case, counsel may inform the court that they are withdrawing for ethical reason, for non-payment of fee, or for other specific reason. So what does ethical reason imply? Well, ethical reason is a coded term, if I may refer to it that way, which is used to imply that counsel cannot in good conscience continue to represent this client in the matter, or that continued representation of the client in that matter will violate counsel's professional or ethical obligation. And this will arise in situations where, for example, counsel comes to realize that the client has lied under oath. There's an obligation, or let us say maybe in the case of a murder trial, a counsel has been asserting that the client was not the one who committed the crime, that a third party committed the crime. And then counsel came to realize that all this while the client has been lying to them, that they were actually the one that committed the crime. And there is evidence to show that, which of course you will not disclose that evidence to the court or to the opposing party. So what counsel cannot go before the court now and say, I'm withdrawing from representation. The reason is because this client has always insisted that they didn't commit the murder, but now I have come to realize that they were actually lying to me and to the court, that they were the one that committed the murder, and for that reason I need to withdraw. No, counsel cannot do that. So what counsel can simply say in this case that they are withdrawing for ethical reason. And when counsel is withdrawing for ethical reason, that is a coded way of telling the court or the judge that, okay, there must be something serious, and it is something the court should not push further to try to inquire, because it may inevitably result in the disclosure of confidential information. So where a client has perjured or lied under oath and counsel comes to realize that there's an obligation on counsel, of course, that they cannot continue to assert that something is true when they know that it is false. And the example we give, counsel cannot go after having realized that the client was the one that actually committed the murder. They cannot continue to appear before the court insisting that a third party, or continue their previous argument that a third party committed the crime when actually it was their client. So in such a situation, counsel is ethically obligated to withdraw from representation. And they have to withdraw without disclosing the facts that have come to their attention before the court. So to address such dilemma, what they need to say is that they are withdrawing on ethical reason, without disclosing, of course, the details. One other important thing that we need to note with regards to the Supreme Court decision in R and Cunningham is that one of the reasons counsel can give based on that decision is that they are withdrawing for non-payment of fees. Well, the fact, though, is that such a disclosure may actually amount to disclosure of confidential information, because when you go to open court and say you're withdrawing for non-payment of fees, that's a very huge information, confidential information you've basically thrown out there. Depending on the nature of the case, that may have some adverse impact on your client. Let's say, for example, the client, it's maybe the client is maybe suing a big corporation, right? And because of the contentious nature of the litigation, the matter is dragging through. And counsel comes and say, well, I'm withdrawing for non-payment of fee. Basically, you've informed the opposing party that your client seems to be broke. Such disclosure may result in the other party probably dragging that litigation further. Having known now that your client has some financial difficulty, they may drag that litigation much further so as to kind of force your client to settle for peanuts or to basically bankrupt the client. So in that case, the disclosure of that information that confidential information may actually be adverse to your client. So where counsel is withdrawing for non-payment of fee, which is allowed in R. Cunningham, counsel have to be very careful about disclosure of that particular reason. Before they can disclose that they are withdrawing from non-payment of fee, they have to analyze the circumstance of that case to ensure that this is one of those cases where the disclosure of this kind of information will not have an adverse impact on the client. Disclosure of such information in a criminal law matter may not really have adverse impact on the client, because if the client cannot pay their fee and counsel is withdrawing, the client may have the option of legal aid, right? But in civil proceeding or in civil litigation, such disclosure may work adversely against the client. So R. Cunningham is a criminal law matter. So the Supreme Court says that lawyers can give that as a reason for withdrawal. Yeah, it's criminal law matter that may not have an adverse impact, but that might not be the case in in civil matter. So another exemption we are going to be looking at is legislative exemption. And under legislative exemption, maybe to discuss this exemption, we need to refer again to the Code of Conduct, specifically Rule 3.3-1B of the Code of Conduct requires lawyers to disclose confidential information where required by law. So disclosure of confidential information where required by law is an exemption to the duty of confidentiality. So here we are talking about situations where you have statutory interference with confidentiality of privilege. So here we are talking about situations where a law is passed, a statute is passed, which imposes an obligation on lawyers to disclose confidential information, for example, to state agents in a particular situation or situations. So the fact is that solicitor-client privilege is not absolute right. It's a charter right, and just like many other rights, there are limitations, right? However, statutory interference with solicitor-client privilege or the duty of confidentiality is permitted, but it is permitted only to the extent that it's absolutely necessary in order to achieve the objective of the enabling legislation, right? So such legislative exemption, that is where you have a statute or legislation compelling lawyers to disclose solicitor-client privilege information. That would be clearly a breach of charter right, because solicitor-client privilege is a charter right. Hence, any legislation breaching that right or that charter right will have to be subject to the scrutiny. Will have to be subject to scrutiny in the court. So basically, it has to pass the test of constitutional validity. That legislative provision has to pass the test of constitutional validity, which will of course require first determining whether there is a breach of charter rights, and if there is a breach, Section 1 analysis of the charter, whether that breach is justified. So any legislation interfering with solicitor-client privilege will have to pass this test. So let us look at some case laws that helps us, or that will give us a better understanding of this legislative exceptions and the tests that must be passed before, one, such legislations are even valid, and secondly, whether the disclosure of the solicitor-client privilege is allowed in a particular situation where such legislative exemption is being invoked. So the first case we are going to be looking at is the case of Goodies and Ontario. So in Goodies and Ontario, a journalist sought access to record pertaining to allegations of sexual abuse by offenders, sexual abuse of offenders by probation officers in Ontario. So this was an access to information, a sort of access to information request. The journalist sought from the Ontario government. So Ontario refused to disclose the information on the ground that the information being sought by the journalist are solicitor-client privileged. So the journalist, of course, appealed the matter to the Privacy Commissioner. The Privacy Commissioner ordered the disclosure of the documents, and Ontario sought a judicial review of the Privacy Commissioner's order or decision in that matter. So at the divisional court judge ordered the entire record being sought by the journalist should be disclosed to the counsel for the journalist to enable counsel to prepare for the judicial review. And this has to be disclosed on the undertaking by counsel that they will not disclose the record to the journalist. So basically, the divisional court was saying this solicitor-client privilege information for the purpose of the judicial review before us, the information should be disclosed to counsel, to the journalist seeking that information to enable counsel to prepare for the judicial review, but counsel should not under any circumstances disclose the record to the journalist. So, and the decision of the divisional court judge was, of course, subject of appeal that went as far as Supreme Court. So in R and Goodies, in Goodies and Ontario, rather, not R and Goodies, in Goodies and Ontario, the Supreme Court laid down what was known as the absolute necessity requirement. So the absolute necessity requirement is to the effect that disclosure of record, solicitor-client privilege record, pursuant to a legislative enactment, disclosure of solicitor-client privilege information pursuant to a legislative enactment can only be ordered or be made where the absolute requirement, the absolute necessity requirement is met. So, and that raises the question then, when is the absolute necessity requirement met? The absolute necessity requirement is met where the disclosure is absolutely necessary in order to achieve the objective of that legislative enactment or the enabling legislation. So absolute necessity is met where the disclosure of the solicitor-client privilege information is absolutely necessary to achieve the objective being sought by the enabling legislation. So in this particular case, the court was of the view that that test is not met because the sole purpose of disclosure, which was ordered by the court or the lower court in that case, was to help the journalist counsel to prepare for judicial review arising from the matter. And that was not the absolute, that was not the objective of the legislation in this particular case. So that was not the objective of the legislation. So in essence, the disclosure being ordered by the lower court in this case does not align or is not in any way related to the objective which is being sought by the enabling legislation. So to better understand the absolute of, to further understand the absolute necessity test, we are going to be looking at another important case, which is also related to this particular test, though in this case, we're going to be looking at a case from a provincial Supreme Court as opposed to the Supreme Court of Canada, but that provides us with a better insight. That's more like a kind of contra Godis and Ontario, and that is the case of merchant, law society and merchant. So in law society and merchant, a third party filed a complaint against merchant, who is a lawyer and member of Law Society of Saskatchewan. The Law Society began investigation, or they were investigating the conduct of Mr. Merchant, and they applied for an order to enter Merchant's law office and seize records that are relevant to the third party complaint for which the Law Society was investigating. So the application for the order to seize documents in Mr. Merchant's office was refused, and of course, the Law Society appealed the refusal, arguing that the disclosure being sought in this case did not violate or breach the solicitor-client privilege, and that disclosure is absolutely necessary for the Law Society to carry out its statutory responsibility. And the statutory responsibility of the Law Society, of course, include, among other things, regulating the conduct of their members who are lawyers. Now, the particular provision or statutory provision in question here is Section 63, subsection 1 of the Legal Profession Act 1990, which provides, and I will quote, every member and every person who keeps any of a member's record or other property shall comply, mandatory, shall comply with a demand of a person designated by the benchers to produce any of the member's record or any other property that the person designated by the bencher reasonably believes are required for the purpose of an investigation pursuant to this act. So that section of the Legal Profession Act mandates the Law Society to demand the record or any record of a member, to designate a person, in this case maybe an investigator by the Law Society or by the benchers, to require the production by a member of a record requested by this particular designated person or the investigator. So the question then now is whether this provision permits the Law Society to demand for solicitor-client privilege record, which is in the possession of a member of the Law Society who are inevitably, of course, lawyers. So in considering the matter, the Supreme Court, the Saskatchewan Court of Appeal, not the Supreme Court, noted that the requirement to produce any of the members' record in Section 63(1) in a statute dealing with the regulation of the legal profession could be interpreted to include solicitor-client records. So if a statute provision requires the Supreme Court to order its members to produce record, then definitely that record would definitely include solicitor-client privileged information or record. After all, lawyers and law offices are the greatest repository of solicitor-client documents or solicitor-client information. So the Court of Appeal here, or the court here, read or interpreted this provision in the Act to imply that the information being sought here will reasonably include solicitor-client privilege information. So the Law Society, the court noted here, has duty to investigate complaints and the authority to assess privileged record in the course of that investigation. So there is no other way, the court went for that to, of course, hold. There's no other way that the Law Society who have obtained this record. So in essence here, these two conditions met the absolute necessity test. The if record was relevant to the record being sought by the Law Society here was necessary to enable it to carry out its statutory obligation to investigate the conduct of members. That's a statutory responsibility, which is clearly provided in the Legal Professions Act. Secondly, the information being sought from Mr. Merchant, the Law Society cannot obtain it from any other way. There's no other way to obtain that record except by, through the member here in question. So based on this fact, of course, the Court of Appeal there, or the court there, noted that the absolute necessity test has been met in this case, and the Law Society has the right to demand those records from Mr. Merchant, the member or the lawyer. So we'll also look at another case, or one more case, which further highlights the exception, that is the legislative exception to the solicitor-client privilege. And the case we're going to be looking at here is a case of Attorney General, Canada Attorney General, and Federation of Law Societies of Canada. So this case arose as a result of an anti-terrorist financing legislation that was passed by the government, which imposes an obligation on lawyers to collect and keep certain information used to verify the identity of their clients on whose behalf they either seek to transfer or receive money. So the objective of this legislation, of course, is to kind of prevent terrorist financing. To achieve that, it imposes an obligation on lawyers to collect and keep certain information which they use to verify the identity of any client on whose behalf the lawyer either seeks to receive or transfer money. Now, the fact is that some of the information that lawyers are obligated to collect from the client in this case were not really even information that were necessary for the purpose of providing legal services to the client. However, they were obligated to collect those information not just to collect it, but also keep it. So the legislation, in essence, subject lawyers to search and seizure of materials that are required, that they are required to keep. That is the client information. So under this legislation, you not only collect the information, you also keep it. And government agents of the government, especially from the from FinTrack. So this information, of course, are required to be collected and kept by the lawyer and agents of the government, like agent from FinTrack. And FinTrack is more like the financial police, the federal financial police in Canada. FinTrack stands for Financial Transaction and Report Analysis Center of Canada. So this agent at any time can walk into the lawyer's office and demand the lawyer produce information. This information they have previously collected and kept about the client, and produce it to this government agent for their whatever investigation or whatever legitimate use they may have of it. So the Federation of Law Societies of Canada challenged this legislation on the ground that it basically conscripts lawyers as state agents against their clients. And it turns lawyers or the law offices into more like an archive or repositories for law enforcement agents, which they can walk into at any time and demand for any information covered under this legislation. And the lawyer has an obligation to disclose that information. So they were of the view that this legislation actually violates Section 7 and Section 8 of the Charter, and that was the basis for the challenge. So this is not a case of absolute necessity. Absolute necessity arises where the legislation has been held to be constitutional, right? In this case, the constitutionality of the legislation in question here was even in dispute. So we're not even looking at absolute necessity test. We're looking at the validity of this legislative exemption being sought by this particular anti-terrorist financing legislation. So the requirements under this act that lawyers collect and retain record, this is the Supreme Court's ruling, And some of these records are not even required to provide legal services to the client. And that these records are accessible to law enforcement undermines the trust between lawyer and client. And the court was of the view that this relationship between lawyer and client, or trust between lawyer and client, is fundamental to the solicitor-client relationship. So you cannot impose an obligation, a statutory obligation on a lawyer that undermines the trust between a lawyer and client. The Supreme Court in that case was further of the view that the state cannot impose duties on lawyers that undermine their commitment to the client cause. So the statutory scheme in this particular case interferes with the lawyer's duty of commitment to client cause, which was recognized by the courts in that particular case as a principle of fundamental justice. So one thing we have seen so far under the legislative exemption, or two approach under legislative exemption, as we have seen so far, is this. When a legislation seeks to abrogate or breach lawyer-client relationship by imposing an obligation on lawyer to disclose solicitor-client privilege information, the first step is to determine whether that legislation is actually constitutional. And this will, of course, require the charter analysis, whether it breaches the rights and whether that breach is justified under Section 1. If that cannot be established, then that legislative provision is void and cannot even be enforced. And that was exactly what happened in Canada versus AG Canada and Federation of Law Societies of Canada. Then where that legislation has passed these two constitutional tests or charter tests, in which case that legislation has been held to be valid and constitutional, the next step now is to determine the information or the solicitor-client privilege information that is being sought, whether it is absolutely necessary. So this is where the absolute necessity test applies, whether that information is absolutely necessary to achieve the objective being sought by that legislation. So in essence, there are basically two steps here. First, identify the constitutional validity of the legislation that seeks to breach the lawyer-client that seeks to breach the solicitor-client privilege information. If that legislation passes the constitutional test, then the next step is the absolute necessity test. So far in this class, we have examined some additional exceptions to the duty of confidentiality, that is in addition to the ones we have examined in previous classes. So we have seen, of course, some of the exceptions here, which include the innocence at stake test. Remember the 3 stages under the innocence, well, actually 2 stages, but 3 in the sense that there's a preliminary step under the innocence at stake exception. You look at the preliminary step. After the preliminary step has been cleared, then you have stage 1 and stage 2, which of course will have to be cleared before the solicitor-client privilege information is being disclosed to an individual for the purpose of asserting their innocence or where their innocence are at stake. We also talked about the special exemption, which arises in terms of withdrawal from representation. The lawyer cannot disclose privilege information, and the Supreme Court in R. and Cunningham, where they basically set the principle to follow in determining what to disclose and whether disclosure should be made. So that's both a guide for the lawyer and for the court. If time is not of essence, there's sufficient time for the client to obtain another lawyer or to obtain the service of another lawyer. If time is not of essence, the court should not even inquire into the reason why a lawyer seeks to withdraw. If time is of essence, then the lawyer can provide clue as to the reason for their withdrawal without disclosing confidential information. And in criminal matter, specifically, the reason could be either ethical reason, non-payment of fee, or any other reason. And we highlighted the fact that non-payment of fee will actually jeopardize or be adverse to the client if it is disclosed in some civil procedure where that may basically provide some confidential information that may turn out to work against the client. Then we concluded by looking at the legislative exemption to the duty of confidentiality. And of course, we looked at the Goodies and Ontario case where the principle of absolute necessity or the absolute necessity requirement was established. Then there is, of course, we concluded with the case of Canada Attorney General and Federation of Law Societies of Canada, where we also see another element of legislative exemption, which is, of course, even finding out whether the legislation that actually seeks to impose the disclosure of the lawyer-client, solicitor-client privilege information is valid. So first of all, it has to be shown that that legislation is valid. If that legislation is not valid, then you can attack the disclosure or the request for disclosure by attacking the legislation that seeks to impose that disclosure. If the legislation has been shown to be valid after passing through the charter analysis, then the next test, of course, is the absolute necessity test. Here, you're basically going to focus on the information that is being sought, whether that the disclosure of that information is absolutely necessary to achieve the objective sought by the enabling legislation. And we saw that how the Saskatchewan Court of Appeal interpreted that in the case of Merchant and Law Society, Law Society and Merchant. So this is where we are going to come to the end of the class on the exception to the duty of confidentiality. Bye.